You remember when Sean Combs argued that one of his criminal charges should be thrown out over racism? Well, the prosecutors have just responded. Will his claims of discrimination and selective prosecution work? The government doesn't think so, and we're going to break down their counterarguments for you right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. There is a big issue to talk about when it comes to Sean Diddy Combs' upcoming criminal trial, currently scheduled for May 5th, 2025. The question is, will the jury hear all three charges against him? Will the court throw out one of his charges, a charge that carries up to 10 years in federal prison? Why do I say that? Because the government has just responded to Combs' motion to toss out count 3 in the indictment, because essentially Combs has argued that it is built out of racism. Yes, that is an argument that is being put forward. And before I even get into the government's recent response to this, and I'll give you my opinion at the end about how I think this is all going to shake up, I have to briefly take you back to what Combs argued in a motion from last month. So the main gist is that Combs is being selectively prosecuted because of his race. That's the argument put forward by he and his defense counsel. That what makes this case so, as they say, unprecedented is that, quote, no white person has ever been the target of a remotely similar prosecution. And really, the focus is on count 3 in the indictment, transportation to engage in prostitution. And I'll tell you what, I'm going to actually read you what this charge is from the superseding indictment in this case. It reads, from at least in or about 2009 up into and including in or about 2024 in the Southern District of New York and elsewhere, Sean Combs knowingly transported individuals in interstate and foreign commerce with intent that the individuals engage in prostitution and attempted, aided, and abetted and willfully caused the same, to wit, Combs transported, aided, and abetted and willfully caused the transportation of female victims and commercial sex workers in interstate and foreign commerce on multiple occasions with the intent that they engage in prostitution. Now, Sean Combs argues that these allegations, the ones that I just read you, have never been brought before under this specific statute, namely the Mann Act, or what it used to be referred to as the White Slave Traffic Act, which, as Combs describes in his motion, has a, quote, very troubling history as a statute with racist origins, that it was used to target black men and supposedly protect white women from them. That's a quote from Sean Combs' previous filing. And Combs explores that in his filing, explaining that the specific statute that makes up count 3 in his indictment, it was enacted by Congress in 1910. And that, quote, the statute was born out of hysteria that white slavers were preying upon young women, coercing them into prostitution through threats, intimidation, and force. Combs continues, the statute's target was black male sexuality, and from Jack Johnson to Chuck Berry, the statute's most notorious prosecutions targeted famous black men accused of deviant sexual behavior. This case continues the trend. So he starts by arguing that the charging decision in this case by prosecutors shows an improper bias, that there was a discriminatory effect and a discriminatory purpose. Keep those two in mind. We're going to talk a lot about it in a minute, a little bit later. And he argues that the use of escorts, that's common in America today, and that the actual service at issue in this case is a legitimate business. And although the name is redacted in his filing, he says this is widely known, it is widely popularized, this service, and he points out, by the way, that neither that service nor its CEO nor the escorts have ever been targeted by federal prosecutors in the Southern District before. They're not being criminally charged. And yet, he argues, no other person, including no white person, has ever been prosecuted under this act for hiring male escorts from another state. But he claims he is the one who has been singled out, a very successful and powerful black man. Again, selective prosecution. And then he argues, look at other cases. Look at other high-profile white men who have or allegedly have engaged in similar conduct. And he cites former New York Governor Eliot Spitzer, who ultimately wasn't charged for allegedly being involved in an international prostitution service. So Combs' lawyers argue this is all circumstantial evidence of discrimination. And to further prove that, they argue the way prosecutors have handled this case shows a bias, that they have gone out of their way to humiliate Sean Combs, to prejudice a future jury pool with their pretrial publicity of the case. We're going to talk a lot about that a little bit later on too. So in the end, they argue either count 3 should be dismissed entirely, or in the alternative, they're asking the court that they order discovery regarding the government's charging decisions, meaning allow us to investigate why and how the government decided to bring this charge or these charges. Quote, to obtain discovery on a selective prosecution, a defendant need only produce some evidence of discriminatory effect and intent. In other words, a defendant will satisfy that preliminary burden by adducing, quote, some evidence that similarly situated defendants of other races could have been prosecuted, but were not. And that standard is easily met here. So that is the defense's argument. Throw out count 3, or at least allow us to investigate it about why it was brought, because there might be some racial undertones. By the way, little sidebar here, imagine this. You help your little brother land a great job abroad, but when he arrives, that job doesn't exist. Instead, he is trapped in a heavily guarded compound, forced to sit at a computer and scam innocent victims while armed guards stand by with shoot-to-kill orders. Scam Factory, the explosive new true crime podcast from Wondery, exposes a multi-billion-dollar criminal empire operating in plain sight. It's told through one family's harrowing account of sleepless nights, desperate phone calls, dangerous rescue attempts. Scam Factory reveals a brutal truth. The only way out is to scam their way out. So follow Scam Factory on the Wondery app or wherever you get your podcasts. You can binge all episodes of Scam Factory early and ad-free right now by joining Wondery Plus or by going to our link in the description and pinned in the comments. Now, as I mentioned, the prosecution, the government, has responded. And I'm going to start with how they start out in their filing and their response, writing, quote, offering no more than his say-so, the defendant makes the outrageous and illogical claim that federal prosecutors brought one, and only one, of the 3 charges against him on account of his race. Tellingly, the motion fails to mention that the other counts of the very same indictment allege that the defendant engaged in horrific and repeated acts of violence and sexual coercion, harming multiple victims over the course of multiple years. That context alone defeats the motion. And the prosecutors argue that race didn't play a factor into the charges that Combs faced, but rather he's facing these charges because of his, quote, own violent, abusive, and criminal conduct. And what is that conduct? Let's get a little more specific here, because what makes up the racketeering conspiracy charge, the sex trafficking charge, the prostitution charge? Well, the allegation is that Combs engaged in a pattern of abusing women, verbally, emotionally, physically, sexually, for years. And that included transporting women and commercial sex workers and coercing and forcing women to participate in sex acts for his own desire, that he would use drugs or threats or power to get them to do this, to get them to do what he wanted. And how did he carry all this out? Allegedly using his power, his resources, his business empire to carry all of this out, and his practices are violations of federal laws. So in other words, the government here explains that count 3, the count at issue, that transporting of people for purposes of prostitution, is exactly what makes up the core of this case. Quote, the indictment thus makes clear that the transportation alleged in count 3 served the defendant's abusive victims. That count alleges that the defendant transported the same victims identified in earlier paragraphs as victims of abuse. That count also alleges that the defendant transported commercial sex workers, which corresponds to the allegations in earlier paragraphs that the defendant coerced female victims to engage in sexual activity with male commercial sex workers. All 3 counts of the indictment, thus, on their face, charge a common course of conduct arising out of the defendant's abuse and sexual exploitation of multiple victims. Okay, so they're saying it's all connected here. So what does the law say about all this? Well, as the government explains, a defendant who is challenging the government's decision to prosecute, so not challenging the charges, but challenging the motive behind deciding to charge a defendant. In order to challenge that, the defendant bears a very heavy burden. And that's because prosecutors, quote, retain broad discretion to enforce the nation's criminal laws. And they cite case law in support of this. Now, I have to clear something up here. Selective prosecution is not a criminal defense. In other words, Combs' attorneys can't argue in front of a jury in May that prosecutors brought this case because they're racist and therefore he should be found not guilty. It doesn't work that way. Arguing the prosecution hasn't met their burden of proof or that everything was consensual, those are defenses. Not this. But as a separate matter, as a way to get the charge potentially thrown out, you can argue selective prosecution. But as you can see, as I'm mentioning, it is not easy. What do you have to prove as a defendant in order to claim selective prosecution? Well, as the government lays out, quote, to establish a claim of selective prosecution, a defendant must present clear evidence that the decision to prosecute not only, one, had a discriminatory effect, but was also, two, motivated by a discriminatory purpose. It's like what we mentioned before in Combs' motion. Effect, purpose, and we're going to get a lot into that. So the government argues that Combs' motion fails to meet either prong, and we're going to break down why they say each prong doesn't work. But I thought this part was interesting before we even get into the prongs here. The prosecution writes, the defendant spills much ink detailing the origins of the statute charged in count 3, but he cites no law indicating that the legislative history of a statute has any bearing on either prong of a selective prosecution claim, and he makes no attempt to connect that history to the applicable test. Basically, they're saying all that stuff about the history of this law and all that, it's irrelevant. It's irrelevant to the analysis. So it made me wonder, are the prosecutors suggesting, yeah, you got a point. The law does have a troubling history, but doesn't matter. Doesn't matter in terms of the analysis. So let's talk about the analysis. Let's talk about what a court's going to consider or potentially consider. Again, two-prong test to show selective prosecution. The first prong, discriminatory effect. So to prove discriminatory effect, a defendant has to establish that others in a similar situation to Sean Combs have been treated differently, like they weren't prosecuted and that Combs was, that he was singled out. And the prosecutors first address Combs citing other situations, like the Elliot Spitzer case that I mentioned before. Or, Combs mentions this as well, how clients of that escort service that he may or may not have used, the one that's at issue, that they weren't charged under the Mann Act. And then also, Sean Combs referenced this, the scandal surrounding Jerry Falwell Jr., who allegedly had another man have sex with his wife as he watched. And again, those are similar allegations that are made about Combs, that he brought people into his sexual relationships and all that. So Combs cites that one for the idea that couples sometimes have a third party join them, and that's not a crime. That's not a crime that's been prosecuted. So prosecutors looked at all that and they say, none of these people are in the same situation or facing the same kind of allegations as Sean Combs. They don't have the same kind of aggravating factors like in Sean Combs' criminal case. So first, prosecutors explain how Combs is accused of sex trafficking multiple victims through force, fraud, and/or coercion, and coercing them into commercial sex acts, including with male escorts. That's why he's accused of violating the Mann Act. This is not like any of those other incidents cited by Combs. Second, they argue Combs carried out the transportation of victims by using force, fraud, and/or coercion in order to cause those victims to engage in commercial sex acts, and that this was all part of a larger, broader pattern of racketeering activity. In other words, the Mann Act, or the White Slavery Trafficking Act that Combs has an issue with, count 3, the one he wants to throw out, that charge stands together with other underlying crimes to make up the specific racketeering charge that he faces, racketeering conspiracy. And racketeering conspiracy, what Combs is facing, is that there was an agreement to further a criminal enterprise. And prosecutors argue here that the transporting to engage in prostitution, count 3, stands together with other underlying crimes of the criminal enterprise, like arson, narcotics distribution, bribery, obstruction. It's all part of the same thing. There's a connection here. And that this alleged conduct overlaps, and in the same way Combs used his power and his resources to allegedly build an illegal criminal empire, he also allegedly used his power and resources to fund transporting people for purposes of prostitution. That's the allegation. And all of that to say this, quote, nothing in the motion, nothing in Sean Combs' motion, suggests that Spitzer, Falwell, or the other clients of the escort services transported escorts as part of a pattern of racketeering activity, or that they committed any other crimes whatsoever during the same period when they engaged in commercial sex. That distinction further widens the already vast distance between the defendant's conduct and the examples he raises in his motion. Third, prosecutors argue that Sean Combs is ignoring that he allegedly violated the Mann Act not just by transporting escorts, it's not that simple, but also transporting victims of sex trafficking. So therefore, you can't really cite other people who just simply paid escorts. This is very different. Quote, examples of other individuals who may have paid escorts but were not involved in the transportation of victims of trafficking are thus inapt. Fourth, they argue Combs doesn't show that those other people he mentioned, they would have even met the elements of the Mann Act to be charged. That Combs doesn't cite any evidence that Spitzer, Falwell, or the other clients of that escort service transported anyone across state lines for purposes of commercial sex. And there's no indication that Falwell even paid anyone to engage in sex acts. Rather, the article that Combs cited in his motion about Jerry Falwell Jr., all that article simply suggests is that a third party consensually participated in sex acts with Falwell and his spouse. So in other words, this goes to a larger argument put forward by the prosecution that this case isn't about simply Sean Combs having group sex or inviting somebody in to have sex with a partner of his while he watched. It's much wider than that. So the government explains it best like this, that if Combs really wanted to make the proper comparison about somebody who was just like him and wasn't charged like he was, quote, far afield from the examples cited by the defendant, a similarly situated individual to the defendant would be somebody who engaged in violence and coercion as part of a pattern of racketeering activity and who transported not only escorts but also victims of that violence and coercion. Because the defendant's alleged criminal conduct is considerably more serious than anything he accuses these individuals of, he has failed to identify any similarly situated individuals who were not charged. This is fatal to his claim. And also, prosecutors point out that Combs doesn't even argue that the entire indictment is improper selective prosecution, but only count 3. Wouldn't he have to show someone who was charged with racketeering conspiracy and sex trafficking but wasn't charged with the Mann Act to make a proper comparison? It's a fair argument, and yet he doesn't. And the thing about that is the government argues that there are cases in the Southern District where this case is being heard, this very jurisdiction, where you have people of varying races who were charged with the Mann Act and sex trafficking, like wealthy fashion executive Peter Nygaard, a white defendant who was charged in this district with racketeering conspiracy, sex trafficking, and Mann Act violations. Or what about Ghislaine Maxwell, right? The white Jeffrey Epstein accomplice charged with sex trafficking and Mann Act violations. And prosecutors cite other cases from this district where someone is charged with both Mann Act and sex trafficking violations and using the Mann Act to prosecute those who are accused of sexual abuse. So in other words, this is all routine. It's not about Sean Combs' race. It's not about selective prosecution. It is routine where there are aggravating factors like prosecutors claim there are in Sean Combs' case. They write, quote, contentions that a handful of individuals were not criminally charged out of the millions of individuals who reside in or otherwise subject to potential prosecution in the Southern District of New York are plainly inadequate to meet the requisite threshold to demonstrate discriminatory effect. And they cite a case that apparently held, quote, in the absence of evidence demonstrating how many individuals the Southern District of New York prosecutor knowingly failed to prosecute, we cannot say that the district court exceeded its allowable discretion in finding that the defendant did not present some evidence of having been singled out. So in other words, quote, the defendant fails to cite even a single case in which a court has ordered discovery on selective prosecution claims based on such tenuous allegations, and the government is aware of none. So, that was all the first prong, discriminatory effect. They say he doesn't meet it. Now we move on to prong 2, discriminatory purpose. So again, this is all to show that prosecutors engaged in selective prosecution against Combs. Okay, so what do we mean by discriminatory purpose? Well, as the government explains, quote, the second required prong is discriminatory purpose, meaning the defendant must have been selected for prosecution based on such impermissible considerations as race, religion, or the desire to prevent his exercise of constitutional rights, meaning the prosecution selected to prosecute Sean Combs in bad faith. And here, prosecutors argue that Combs has failed to meet this prong as well, that he can't establish any credible evidence that count 3 resulted from a discriminatory purpose. Or as they write, quote, while the defendant slings accusations of racism throughout his motion, he identifies no actual evidence, as opposed to mere assertions that he was prosecuted because of his race. Indeed, apart from speculation and conclusory assertions, the defendant cites no evidence to make that showing, nor could he, because race played absolutely no role in the decision to charge the defendant. And then the prosecutors continue by addressing Combs' argument that, hey, I have the proof of discriminatory purpose because look at the way the prosecution prosecution has gone out of its way to humiliate me, to publicize this case. Remember that argument that I mentioned before? So the allegation that they have tried to prejudice the jury pool with pretrial publicity that, quote, plays on racist tropes, the prosecutor said, if you're referring to when the former U.S. Attorney Damian Williams held a press conference upon the arrest and indictment of Sean Combs back in September, what racist tropes are you talking about? What did he do that was so wrong? They argue that that press conference was in compliance with local Southern District Rule 23.1. That governs against lawyers making any out-of-court statement that goes beyond the public record or is not necessary to inform the public. But take a listen to what Damian Williams had to say. This is a sample.
When Combs didn't get his way, he was violent, and he subjected victims to physical, emotional, and verbal abuse so that they would participate in the freak-offs, and that Combs hit, kicked, threw objects at, and dragged victims, at times by their hair. On one occasion in March of 2016, that conduct was captured on video and later reported in the media. Specifically, Combs kicked, dragged, and threw a vase at a victim in a Los Angeles hotel when the victim was attempting to flee.
And moreover, the prosecutors assert that that press conference and the accompanying press release by the Department of Justice, they are consistent with what they do in other cases. And they even cite the recent sex trafficking case of the White Alexander brothers, Alon, Tal, Orrin Alexander, who we have focused upon a lot here in Sidebar. And remember, Damian Williams spoke out at their press conference.
As alleged, the defendants used their wealth and positions to create and facilitate opportunities to sexually assault women. This conduct, as alleged, was heinous. I stood here several months ago and made clear that this office is firmly committed to prosecuting individuals who exploit and abuse women. I meant what I said. With our law enforcement partners, this office is determined to investigate and prosecute anyone who engages in sex trafficking, no matter how powerful or wealthy or famous you may be.
So the idea here, pretty similar to the Combs press conference, right? And from there, prosecutors address the other evidence that Combs says proves there was discriminatory purpose. For example, quote, the defendant complains that he was not permitted to surrender and was instead arrested by federal agents. This is about when he came to New York and he was ultimately arrested at his hotel. Quote, but the decision not to permit a defendant charged with committing violent crimes, engaging in obstruction, and sexually exploiting victims is entirely consistent with the practice of the U.S. Attorney's Office in other cases. And again, does not provide any basis to infer racial animus with respect to count 3. Or there's another argument that Sean Combs apparently brought up, how so much force was used when his LA and Miami properties were raided by federal agents back in March of 2024. Maybe that shows a racial animus. Well, the prosecutors respond by saying, quote, the defendant repeats his prior complaints about the manner in which search warrants were executed at his homes. That argument ignores that the warrants were executed not by the prosecutors in this case, but by law enforcement agents who are not the subject of selective prosecution claims. Setting aside that the use of force to secure a premises, especially when the crimes under investigation include violence and the items to be seized include firearms, is entirely justified, it certainly does not demonstrate discriminatory purpose when electing to charge count 3. So in the end, the prosecution argued, quote, the defendant has failed to adequately allege that there was anything unusual, let alone improper, about the charging decisions in his case. Because his allegations fall far short of the rigorous showing necessary to make out a prima facie case warranting the disclosure of discovery, much less the clear and convincing standard required for dismissal of count 3 for selective prosecution, his motion should be denied. For the reasons set forth above, the defendant's motion to dismiss count 3 should be denied. Now, my personal take, I think the government's going to win this. I do. I think that when you listen to what they have to say and you put forward this idea of such a difficult burden for the defense to overcome, to show selective prosecution, to me, it doesn't seem Combs was specific enough about how this was discriminatory, putting enough evidence to show that. I got to give him credit, though. Really interesting argument. Haven't seen this one before. We'll see which way the court goes. But again, my personal take, I think the government's going to win this one. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.